Alright, 2021 Code of Virginia, Title 45.2 Mines, Minerals, and Energy, Chapter 16 Virginia Gas and Oil Act, Article 3 Regulation of Gas Development and Production, 1629 Duties, Responsibility, and Authority of the Director. Alright, the Director shall adopt and enforce regulations or the necessary to ensure the safety and sufficient development of the product and production of the gas and oil resources located with the Commonwealth. Such regulations are designed to 1. Prevent pollution. State waters require compliance with water quality standards adopted by the State Water Control Board. 2. Protect the on-site against off-site disturbance of the gas, oil, geophysical operation. 3. Ensure restoration of all sites distributed by gas, oil, geophysical operation. 4. Prevent escape of the Commonwealth of gas, oil resources. 5. Provide safety in coal and mineral mining and coal-bedded methane wells and related facility operations. 6. Control waste for the gas, oil, geophysical operation. 7. Provide accurate measurement of gas, oil production, delivery of the first point of sale. 8. Protect the public health with general welfare. Being an adoption regulation, issuing order for the enforcement of the provision of this article, the Director shall consider the following factors. 1. Protection for the citizen, environment, of the Commonwealth, for the public safety, and environmental risks associated with the development and production of gas or oil. 2. Means ensure safety and recovery of the coal and other minerals without substantially affecting the right of the coal, minerals, gas, oil, the geophysical operators to explore and produce coal and mineral gas and oils. 3. The production of safety and health permitted with the sites of the coal bed, methane wells, and related facilities. C. An adoption regulation or the Director may set and enforce for standing with the governing the following with the gas and oil of the ground distribution, geophysical exploration, the development, the drilling, casing, the equipping, and the operating, the plugging of the gas or oil production, storage, enhanced recovery, or disposal wells, development, operation, restoration, site disturbances, whether gathering pipelines, associated facilities, or gathering pipeline safety. C. Whenever the Director determines that the emergency exists, he shall issue the emergency order without advance with notice of the hearing. Order shall have the same validity of the order issued with an advance notice of the hearing, but shall remain in force no longer than 30 days from the effective day after issuing the emergency order. The Director shall promptly notify the public of order by publication hold the public hearing for the purpose of modifying, repealing, and making permanent with the emergency order. The emergency order shall prevail as against general regulation or order when in conflict. Emergency order shall apply to gas, oil, geophysical operation, in particular a field with geographical areas, subject areas, and subject matters or citation. The Director may also issue conditions or revoke permits to issue notice violation orders upon violation of any provision of chapter regulating adopted thereunder. 3. Issues closures in case of the imminent danger of the person or damage environmental upon history of the violations. 4. Require the forfeiture bonds of the financial security. 5. Prepare and prescribe nature of and from presentation information documentation required with any provision of this article regulation adopted or under. 6. Maintain suit with the county of the city if the violation occurred with a threat wherever the person who has violated threatens violate any of the person chapter is found in order to restrain actual threat and violation. 7. At reasonable times, unreasonable circumstances, enter upon with the property take take action necessary to administer and enforce provisions of this chapter. 8. Inspect and review all property records thereof the necessary to administer and enforce for the provision of this chapter. And for the Director, no jurisdiction here, objections respect to any matter subject to the jurisdiction of the Board as set out in Article 2. Such objections shall be referred to the Board in a manner prescribed by the Director. Alright, that was 1629. Duties or responsibility authority of the Director. Alright, 1630. Powers and duties responsible of the Inspector. The Inspector shall administer with the law of the regulation shall have the access to the records and property necessary for this purpose. For this purpose, he shall perform all the duties designated by the Director pursuant to 45.2.105 with the pertaining records of the following. 1. Each application of the gas geophysical operation, each permitted with the gas, oil, geophysical operation, meeting actions and orders of the Board. 3. Each position mining coal within 200 feet or through a well. 4. Each request for the special plugging by the coal owner or coal operator. And 5. All other records prepared pursuant to this chapter. B. The Inspector of any of the department employed with determined by the Director shall serve with the principal executive of the staff of the Board. C. The Inspector may take charge of the well or core hole operation, pipeline emergency operation whenever a well or core hole blowout, release hydrogen sulfide, other gas, or other serious accident occurs. Alright, 1631, permit required gas well geophysical operation, coal bed, methane gas environmental assessment. No person shall commence with ground disturbing activity with the well gathering pipeline, geophysical exploration, associated activity facility with the structure without first having been obtained with the director of the permit. With the conduct such activity, having the permit application of the permit modification application filed with the director shall verify by the permit application shall contain all data, maps, plats, plans, other information required with the regulation or the director. B. Each permit issued on or after July 1st, 1996, new permit issued by the director shall be issued only after the following activity: geophysical operation, drilling, casing, equipping, simulating, producing, reworking with initial production zone, plugging well, construction, operation, gathered pipeline, application for the new permit to conduct the geophysical operation as accompanied by application fee of $130, an application new permit for any other action accompanied by the application fee of $600. For a permit issued prior to July 1st, 1996, the permit commenced reworking of the deepening, plugging of the well of the activity previously approved with the permit on the site with the permittee shall first obtain with the permit modification from the director for each application of the permit. Modification shall be accompanied by the permit modification of $300 for the permit issued on after July 1st, 1996. Prior to commencing with any new zone completion, the permit shall first obtain with a permit modification from the director. C. Each permit operation provided under this section shall conform with the regulation orders of the director of the board. Permit terms of the condition required by and provided for under this article and conflicting with any of the provision conservation order issued pursuant to the provisions of Article 2 with the terms of the condition of the permit shall control. In such event, the operator should return to the board of the conservation conservation orders in light of the conflicting permit. Each permit shall be responsible for all the operation activity disturbances associated with the permitted site. E. No permanent modification shall be issued for the director unit until he has received the applicant written certification. 1. All notice requirements of the article have been complied with the targeted or together with a proof thereof, and 2. For the application right with the conduct of operation set forth with the application of the operation plans. If the permit is required to drill any coal bed methane gas or convert any methane drainage borehole into a coal bed methane gas well. In addition to other requirements in this section, every permit application of the coal methane gas well shall include 1. The method of the coal bed methane gas well operator will use the similar as a well. 2. Assign consent with the coal operator of the east side of the soil seam that located within 750 feet of horizon of the proposed well location. Application per purpose for the stimulating 200 vertical feet above the coal bearing stratum of the application proposed stimulated. B. For the consent is required for the subsection 1 with the containing of the lease of the other such agreement. The 2. For the containing of the instrument of the title. 3. In case the coal operator cannot be located, identified with the operator complied with the statute 45.2.16.18. Provide with the pooling under entered pursuant to the statute 45.2.16.20 or 16.22 in such order contained with the finding of the operator exercise with the due diligence in attempting to identify located with the coal operator contained with the instruction of the order consent with the required for the subsection shall be deemed to be granted for any tract with where the title of the coal is held in multiple owners if the applicant has obtained with the consent with the simulated with the continents holding a majority interest in tract with none of the coal tenants leasing the tract with the coal development and requirements on consent contained in subsection in no way considered impair, bridge, or affect contractual rights or obligation arising from the coal bed methane gas or coal bed methane gas lease entered into prior to January 1st, 1990, between the application and the name of the coal operator, any extension of the renewal thereof of the existing such a lease, contractual arrangement, any extension of the renewal thereof, that shall constitute a waiver of the requirement for the application filed for the additional signed consent. 3. The unit map, if any, if approved by the board. G. No permit is required for the chapter activity conducted for the area with the tide, water, Virginia, wherever the drilling is authorized under subsection B. 45.2.16.46, granted with the environmental impact assessment required by 45.2.16.46 has been conducted an assessment and it has been reviewed by the department. H. Application of the permit for the gathering pipeline or gas or oil well over the coal bed methane well shall be identified with the permit for the application of any identified in the permit application as cemetery as identified in the United States Geophysical Lodge Survey topographical map with located with the routine field of review within 100 feet of permitted activity. Alright, The operative of the coal bed methane will be drilled within 200 feet of the cemetery should comply with the written quote of the aim of the person owning the interest of the private cemetery with the authorized agent of the public cemetery. If the operator suspends operation period for 2 hours before 2 hours after any burial service takes place on surface area of the cemetery. However, if the well operator mine operator determines that such suspension of the operation will adversely affect the safety of the well operation mine operation, the operator shall be under no obligation to comply with the request. Operation of well shall continue. That was 1631. 1632. Notice of permit application, permit modification application for the required for the content. And within 1 day with the application for the permit of the gas oil with the operation filed with the application shall provide with the notice application with the following person: every surface owner, coal owner, mineral owner of the tract will be drilled with every coal operative registered operation plan with the department activity located with the tract to be drilled. 3. Every surface owner on the tract where the surface is to be disturbed. 4. Every gas royalty owner within 1/2 the distance of the from 45 to 16 with the type of the well, 1/2 of the distance of the nearest well completed with the same pool, whichever the less to with the boundary of the dwelling under established pursuant to the provisions Chapter 5 of every coal operator has applied with the obtained mining prospecting permit with respect to the tract located within 500 feet of the proposed well location with the case of the proposed coal bed methane gas well location within 700 feet of thereof. 6. Every coal owner, mineral owner of tract located 500 feet of the proposed location in case of the proposed coal methane gas well location 700 feet of thereof. And 7. Every operative of the gas storage field certified with the State Corporate Commission as a public utility facility. Those for the certified area include well location, well certified boundary has been 1,250 feet with the proposed well location. B. Within 1 day on which the application for the permit modification of gas oil operations follow the application requires that such modification shall be provided with a notice for the application to all of the person listed in subsection A who may be directly affected by the proposed activity. C. Within 1 day of the day with the application with the permit and geophysical operations submitted for the application shall provide the notice of those persons listed in subsection A 1, 2, and 3. D. Each notice required whether given in pursuant with subsection A or B or C shall contain the statement of the time in which the objections may be made with the name and address of the person to whom the objections shall be forwarded. Only person entitled with the notice of the subsection A, B, and C will have standing to object with the issuance of the proposed permit with the permit modification for a gas or oil geophysical operation as they use may be. Upon receipt of the notice, any of the person may waive the writing of the time of the right of the object. Within 7 days of the application of the permit is filed with the application shall provide with the notice 1 with the local governing body with the chief executive officer of the locality wherever the well is proposed to be located, and 2 with the general public through the publication notice with at least 1 newspaper for the general circulation and in the locality wherever the well is proposed to be located. F. An application shall make the reasonable effort to provide with the notices required in subsection A, B, and C. If an applicant is usually identified with the located with the person to whom notice is required with the notice provided within the clause 2. If it is subsection E considered sufficient to the notice of such person, the date of the notification shall be the date of the publication. That was 1632. Alright, 1633, binding financial security required. To ensure the compliance with all the regulation permitting with the permitted active with the furniture of the report, the other information required with the board or with the director of the breach permit applicant shall be given the bond security acceptable to the director payable to the Commonwealth. The election of the permit application cash bond may be given with the amount of the bond required to be sufficient shall cover the cost of the properly plugging the well for showing the site, but in no case shall the amount of the bond be less than $10,000 per well plus $2,000 per acre of disturbed land calculated with the nearest tenth of the acre of each bond shall remain in force unless the director may require with additional bond financial security as well for the proposed drill in the tidewater of Virginia. B. Upon the receipt of the application for the multi-permits for the gas oil operation and for the required for the permit application of the director, and the requiring separate bond of the permit required for the blanket bond with the amount of the blanket bond shall be filed with for 1 to 10 wells, $25,000. From 11 to 50 wells, $50,000. 51 to 200 wells, $100,000. For more than 200 wells, $200,000. For the purpose of calculating blanket bond amounts, the 1/10 of the acre, the 5 acre of the distributed land, for the separately permitted for the gathering pipeline shall be equivalent into 1 well with the director shall adopt regulation for the release of the acreage for the calculated the blanketed bond amount separately and the permitted for the gathering lines and gathering pipelines in case wherever the sites have been stabilized. See, any gas oil operator who elects to post a blanketed bond shall pay into the gas oil plugging and restoration fund these fees assessments required under provisions 45-2-1634, which is the next one. Gas and oil plugging restoration fund. A. There is created with the state treasury with the special non-reverting with the fund with the known as the gas oil plugging and with the restoration fund referred to in this section is the fund. All payments made with the fund with the gas oil operators with the collection of the debt with the expenditure made from the fund with the all interest payment that made within the fund pursuant with the provision of the section should be made to the state treasury with the credited with the fund and credited to the fund. But the interest earning with the money within the fund should remain with the fund and be created to the fund. But the fund should be established on the books of the comptroller of any monies remaining in the fund, including the interest thereon. The end of the fiscal year shall not revert to the general fund and should remain in the fund with the expenditure of the disbursements from the fund shall be made by the state and the treasurer of the warrants that issue for the comptroller upon the written request signed by the director of his or the designee. Each permit with the operating under the blanket bond with the pursuant of the statute 45-2-1633 shall annually pay with the fund amount with equal to $50 multiplied with the number of permits that they hold. Such payments submitted with the annual report required in statute 45-2-1640 with that payment is interest accruing with the fund in total of $100,000 whenever the director term of the fund balance is below the $25,000 the due uncollectible debts. The director shall assess the fees for the $50 permit per year with each payment and permittee with a blanketed bond with the fund balance once again reaches $100,000. See, money of the fund shall be used solely for the purpose of supplementing the bond proceeds in order to pay for the full cost of plugging, restoration, event, and the blanket bond forfeiture. See, the amount in which of the cost plugging with the restoration exceeds the amount of the gas oil operator forfeited line bond shall the concept of the debt with the operator within the Commonwealth of the director authorized to collect such of the debt together with the cost of the collection through the appropriate legal action. All monies collected pursuant to the subsection left for the cost of collection shall be deposited to the fund. In the fund, no permit is issued for the gas oil operator until he is reimbursed the Commonwealth for any debt incurred pursuant to the provision of subsection D. If in an event of the discontinuance of the fund, any amount of the fund shall be returned to each of the gas oil operator with the blanket bond portion of the number of permits under the blanket bond for each operator. Of 1613, the gas oil plugging restoration fund. Or 1635, expiration permits. Each permit issued with pursuant of the chapter of this chapter shall expire within the 24 months from the date of the issuance unless the permit of the activity has commenced within the time period that an operator may renew the existing permit additional 24 months by submitting a written request containing with the coal's operator approval of the meeting, remitting $325 renewing fee no later than the expiration date. 1636, abandonment or the necessitation of the well or core hole operation plugging required. Upon the abandonment of the necessitation of the operation of any well of the core hole of the gas oil, the geophysical operator shall immediately fill and plug the well core hole in a manner required by the regulation enforced for the time of abandonment or the operator's necessitation. Or 1637, an objection for the permanent hearing. A objection to the new permit with the permanent modification may be filed with the director by any person standing on the set of the statute 45-2-1632. With the set of the objections will be filed with the 15th day of the objection party received with the notice required with the statute 45-2-1632. Any reason person objecting to the permit shall state with the reason with the objection to be with the objection. Only objection to the permit with the permit modification made with the rate of the surface owner are 1. The operator's plan with the soil of the erosion sediment control is not adequate with no other effect. With the measure of the addition with the requirement of the well's water protection string with the necessary with the protect the freshwater bearing strata. 3. The permit located will constitute a hazard of the safety of any of the person. 4. The location of coal bed methane well with the coal bed methane well pipeline unreasonably infringe with the surface owner. Uses of the surface owner along with a reasonable alternative site with available the unit the granting with the objection will not materially impair with any of the right contained within the agreement. Valid in time with the objection between the surface owner and the operative predecessors for the successors of an interest. And 5. If the surface owner's interstate park commission location of the well with the pipeline unreasonably infringes with the surface owner for the surface of the tow line with a reasonably alternative site with available with the unit granting with the objection not partially impair any right with the contained in the agreement of valid at the time of the objection between the surface owner and the operative predecessor successor and interest. See, the only objection to the permit and permit modifications that may be derived with the royalty owner over the proposed well work. 1. Directly infringes on the royalties owner's gas and oil interest. 2. The rent is violative of the objection royalty with the owner's property statutory rights with the against side with the contractual rights. 3 would adequately prevent the escape of the Commonwealth gas oil resource to provide with the accurate with the measurement gas oil production delivered to the first point of sale. D. The objection to the permanent modification may be raised with the coal owner of the operator pursuant to the provisions of statute 45.2, 1611, and 1612. The only objection to the permanent modification may be raised with the mineral owner with those going to have the raised by a coal owner in 45.2, 16, and 11. So when the mineral owner makes the objection affirmatively proves that it does not in fact equal force of the mineral in question. Alright, F. The only objective to the permanent modification that may be raised with the gas storage field operator are those in which the gas storage operator that firmly approve of the proposed well work adversely with effect of the operation of his or her gas storage field certified by the State Corporation Commission. However, there is nothing in the subsection construed to preclude with the owner of the non-storage strata with the filling from the drilling well for the purpose of reducing oil, gas, and stratum above the below the storage stratum. D. The director shall fix for the time and the place for the informal fact-finding with the hearing concerning the objection filed for the pursuant of the section of the hearing shall include be scheduled not less than 20 no more than 30 days for the objection is filed. The director shall prepare with the notice of the hearing stating all of the objections by which it was made with the time of the copy of the notice by certified mail with a return request required at least 10 days prior to the hearing with the date of the permit applicant with the two of the every person with the standing to object as prescribed in the statute 45.2, 1632. Each of the hearing with the parties, all of the fails to come to an agreement, the director shall proceed to decide with the objection pursuant to the provision of Administrative Process Act relating to the informal fact-finding procedures. 1637. 1638. Appeals for the director's decision of the board. Any person standing over the provision of statute 45.2, 1632 with agree with about the decision of the director may appeal with the board limitation imposed with subsection B by petition with the board filed within 10 days following the appeal decision. B. With no petition appeal with the may raise any matter other than the matter that was raised by the director of the petitioner and put in the issue by the application objection proposal of the claim made with the specified with the writing and formal fact-finding hearing under statute 45.2, 1637 leading to the appeal decisions. 1639. Person required to register designated agents. A person who owns a well with a drill well to complete the well's work with the operators of waiting well with the gathering pipeline conduct with the ground for distributing geophysical exploration of the transport gas oil up to include with the first point of the sale shall register. Move of the director shall provide with the name and address of the official with the title of the person in charge of the operation in this Commonwealth. Any person registration subsection A shall designate with the name and the address of the agent who shall be with the attorney in fact with registration for the purpose set forth in this section. Designated agent shall be the resident of the Commonwealth with the notice of the order of communication and the process of issue pursuant to the chapter may be served upon otherwise delivered to the designated agent and for the operative designated as an agent shall remain in force until the director is notified of the rating of the designation, termination, and designation of the new agent. That's 1639. 1640. Report of permitted activity production required contents. A. Each holder permitted of the gas or over the well of the gathering pipeline shall monthly with the annual report for the activities prescribed by the director of the trust of the reports shall be made with the purpose of obtaining information regarding the production and sale of the gas or oil of the resources, as well as information concerning the ownership and control of the permitted activity following such the report by the permittee shall be the conditions such for the permit with every annual report with the permittee shall contain certification such for the permit shall have been paid severance for the tax levy under provisions of the 58.1, 37.12, 58.1, 37.13, 58.1, 37.41. At this time of the permittee filed with the monthly annual reports are required in subsection A, the permittee shall have the time of the copy of the report mailed to the Commissioner of the Revenue Public Subdivision wherever the permitted well is located. 1640. 1641. Develop a gas or oil water well. If any of the well drilled for gas or oil that does not produce the commercial or the paying quantity for either reach for the well may be developed as a water well upon the request of the surface owner of the property over which the well is located. Any such development of the water shall occur only after the notice of the given and for the director for their approval to have been received. The development of the water well shall be performed according to the applicable state of the local requirements unless the gas oil operator surface owner of the otherwise agree with the surface owner shall pay with the gas oil operator with the reasonable with the something of the casing of the tubing set with the left on the wall with the would have the otherwise removed upon plugging on the well over the well. Of 1641. Alright, 1642, orphan well-funded orphan wells. A. There is hereby created with the state treasury with a special non-reverting fund known as the Orphan Well Fund, with the referred to in section A of this fund as the fund. All monies appropriated into the surcharge of the collective of the pursuant of subsection D, with the shall be paid with the state treasury for the credit of the fund, with the interest earned with the monies in the fund shall remain in the fund and be credited it. The fund shall be established on the books of the comptroller, or any of the monies remaining in the fund, included with the interest thereof at the end of the fiscal year, shall not revert to the general fund, but shall remain in the fund. Monies from the fund should be solely for the purpose of the restoration, plugging with the orphan well, with expenditure for the disbursement of the fund shall be made with the state treasurer on the warrants issued by the comptroller upon the written request of the director of his designee. B. If the director conduct with a survey to determine the conditional location for the orphan well of the Commonwealth. A. Shall establish priority for the plugging of the restoration identified with the orphan well for the plugging and restoration of the orphan well of lawsuit that pose imminent danger for the public safety shall have the highest priority. C. If performing the duties under this section, the director shall make with reasonable efforts with identified by the obtainment of the permission of the surface operator owner prior to the entering of the surface owner's land. In all cases, the director shall, as soon as practical, call for the published in the newspaper the general circulation for the county and city where an orphan well is located, notice of the proposed plugging and the restoration work of the conducted with the property. D. Each property will apply with a new permit active with the geophysical operation will pay $200 surcharge with the new permit, and no per permit into the fund surcharge will shall continue with the director determines all of the orphan wells in the Commonwealth are properly plugged and the sites are properly stabilized. E. In the event of the discontinuance of the fund, any of the amounts remaining in the fund shall be paid for the gas oil plugging restoration fund created in pursuant of Statute 45-2-1634. And that was 1642. Alright, 1643. Interference by injection well of the groundwater supply. A. For the purpose of the section, beneficial use meaning the same as the defined in 62.1.255. Groundwater meaning the same with the term in 62.1.255. B. Any person who owns the operating injection well with the manner with the proximity for the cause for the contamination for the diminution of the groundwater beneficial by even any of the person reside with the lesser of the one. The area of the review required with the U.S. Environmental Protection Agency for the permanence of such injection well, or 2, 1/2 mile radius of the well shall be provided. Person with a replacement water supply with a replacement water supply shall provide with the person water the equivalent quality quantity that was well as was provided by the groundwater prior to the contamination or diminution water supply result of the operation of an injection well. With the replacement water supply shall include the provision necessary storage service facilities. See, the section shall apply with any injection well operating under a permit from the director. 1643, interference by injection well with the groundwater supply. Alright. 1644, safety of the safety and coal bed methane gas oil geophysical operations. The director shall inspect with the permitted coal methane well with the related facility operation to ensure the safety of the personnel and the permitted site of the inspection review of the hazardous condition created with the imminent danger. Director shall issue the closure order pursuant to the statute 45-2-1629 and requiring the area to be cleared with equipment removed for the use for the except for one work of the necessary to continue with the vent methane for the active of the underground mine, and such work can be done safely. And 2, that any work necessary to correct and eliminate imminent danger for the director shall lift the closure order when he finds the imminent danger has been corrected or eliminated if the inspection reveals any other condition that creates the risk of the safety and health of any of the person permitted. Director shall notify the Department of the Labor and Industry of the actions under Title 40.1 as applicable. Alright, and that completes Section 3, Regulations of Gas and Oil Development Production.